Hi, welcome to Brittany and Paige who are here with me. And welcome to those of you listening by recording. Um, since this is a mandatory one, of course, I do get quite a few listening to the recording because of the points, but I hope you listen to it for more than just the point value, uh, because the big points and the big value of it is learning some of the basics of how things work in court cases as opposed to being in the dark and not knowing why we're doing anything. And why do we care about this money stuff? Or what are you saying damages? You know, is it only physical damages to a car, or is it the money awarded to somebody? And lawyers talk about it as the money awarded, the damages. um, Module 5 objectives. Personal injury documents, damages to property, damages for physical harm. So when we talk about the creator of the course laid it on the line right there, calculate damages um, from a non-law point of view, from let's say a car repair or a physician point of view, damages are not money, but from a lawyer's point of view, the damages are the money. Any questions or problems with that? A strange use of the term damages, but it's how it's used in the law. Comments? Kind of odd. If you can remember that it is odd, it will help you remember the concept, though. Whether you work in this field or whether you work in other fields of law, one area of law is not totally hermetically sealed from any other area of law, though. Um, And I sometimes compare things to family law, and people say, well, what does family law have to do with real estate? What does it have to do with torts? What does it have to do with contracts? Everything. What does it have to do with corporations? Everything. Why? If you are helping a lawyer work on a divorce case, um, or a number of divorce cases, how does the lawyer gain the money to pay a paralegal, a highly qualified paralegal? Does anybody know? Brittany or Paige? What kind of cases? Would it be poverty cases where it's all about child visitation, where everybody's impoverished? Would that earn the lawyer money to pay a qualified paralegal? What do you think? Pro bono, publico, um, where the lawyer's working for free, or where the lawyer gets a down payment from somebody's uncle and the uncle will not pay anymore because can't afford it. No, Brittany says no. No, it comes from people who have assets. And people say, well, assets, well, that's dollars and cents. No, most people who have assets don't have much for dollars and cents. But what have they got? They've got all this stuff that people pay no attention to when they're in school. They have real estate, they have contracts, they have corporations, they have, um, oh, they have lawsuits that they are about to win or could win. They have personal injury claims. And what are those? Those are tort claims, right? And people say, well, how could you split up a tort claim um, in a divorce? Believe it or not, you can. If you can't, you can garnish it if somebody doesn't pay their child support. You can garnish just about everything. And I'm using garnish in a generic sense. It's technically not called garnishment in my state, but somebody doesn't pay their support. We've gone after all of these things. I haven't actually gone against personal injury claims, but I've gone against contract claims. We have negotiated for personal injury claims and, of course, unpaid wages. Um, Personal injury claims that have not been completely sued out and won yet. are actually have a name. They're called choses in action, and they're called in bankruptcy and in other law. They have other titles, contingent unliquidated claims. And you say, well, how can a contingent unliquidated? In other words, it isn't money yet. A contingent just means there's still a chance of losing. Unliquidated means it's not money yet, but you can actually seize a share of something like this. And that sounds really bizarre, doesn't it? I think it sounds bizarre. I would never have thought of that before I became a lawyer. Um, Never. I would not have thought about that while I was before I started preparing to be a lawyer, at least. And even in law school, I don't think I thought of all of the types of things that could come into a case. And of course, a lot of these could come into a deal of different kinds other than family law, but they could definitely come into, say, a family law. If you know about these things, you are ahead of the game. Um, and of course, we sort of touch on some other things related to personal injury. Um, like that we don't deal with directly, like claims against insurance companies and the the no fault world, um, no fault claims for like social security, disability, um, no fault claims for workers' comp, unemployment comp. There's a whole world of things other than damages, but damages are what we are focusing on now, which is the money that comes in or could come in. It's contingent, but we have to try to figure it out even during fairly early stages of the lawsuit. We try to figure it out. The oddity is, though, that some are hard to calculate. And talking about family related law, we are going to have a special event, um, which is this Thursday. And I'm inviting all of you to come. Uh, and we're going to have it at 6 p.m. Central Time. Um, and I will send out I will send this out. So you'll get this as a link. You can't pick it up off the screen, of course. And then you'll be able to go in and then you'll have to type the word protect in there. And that's a club activity, but you don't have to join to attend one activity. You do join if you want to help plan the next activity that we'd be doing in the summer. But it is people that are in it are enthusiastic. They enjoy being part of it, and this was one of the things that they've students, former students like alumni, and that are involved with the club. This is what they voted on that they wanted. They would like to have us deal with the domestic abuse problem. Um, and that relates somewhat to what we did the other week, doesn't it? With the woman being attacked by her own husband. Terrible, terrible situation. But the lawyer who created the course must have also had experiences dealing with people in that situation, just as I have. Um, in unintentional cases, though, where somebody is damaged in a car accident or something like that, of course, we calculate damages to property. Fair market value is kind of an odd concept. It sounds like it's all about fairness, but it isn't. It's not about fairness precisely. It's basically what is something worth in the marketplace. Um, what would it sell for? What would it sell for before it was totally destroyed? How's that? And normally it's what would it sell for when it's not a so-called fire sale or forced sale? What would it sell for in an ordinary transaction? Uh, I'm trying to give folks like some memory tools, um, general and special for anybody that's not already worked on this. Um, I would start with the word special. The word special sounds like it's an oddity or different type of damages, but actually, it's what I would have called regular damages. Um, it's more similar to in a contract case. You look for specific bills. Well, give me the dollars and cents, the exact dollars and cents that are owed. So, special seems not very special to me, but that's kind of how I memorized it. Does that help? Do you think that'll help your classmates? And so my memory is to go by a sibling. Think of overalls and siblings. Overall is like um, bib overalls or something like that. But special is bills, sib. Special is bills. So your ordinary bills are actually um, called special damages. But when you see the context of it, that very frequently in severe personal injuries, the general damages are overwhelmingly larger than the special. Um, so it's like the opposite of a contract case. In a contract case, you have uh, the ordinary dollar and cents items, and then other stuff might be extra. There might be some extra um, money owed due to delay and things like that when you look at the fine print of the contract. But in personal injury, things like general overall losses, physical harm, um, the sort of extreme damage to a human being and things, those are called general damages. General damages are more humanistic, you might say. Person has, and they're not written in stone anywhere. There's no law that says that if somebody is um, a paraplegic, that they get exactly $560,000. No state has done that. Um, and it doesn't say that they get $5 million if they become a paraplegic as a result of somebody else's fault. There's no law like that. So general damages are more estimated damages that a jury or settlement people who settle it, they have to figure it as well as they can. Um, just reminding you folks of what happens in a personal injury claim. We don't have a lot of slides tonight, so if you can come up with some questions, that helps. Um, a lot of a lot of damages items is going to be really reading through step by step by step. It's hard to um, other than trying to give you some memory tools for the oddities, I would say just read it through. Um, those that have either been involved in litigation or have taken the civil litigation course, this is easy because you already have created these things, but summons, complaint, and then answer by the defendant, certificate of representation and parties. Um, in most states, it there's some kind of a format that the court wants. but basically, you're telling the court who is representing whom, and certifying that certain lawyers are representing certain people. There may be more than two parties, of course. There may be a couple of drivers, passenger, um, you know, there may be an owner of a car that was a defective car that should have been repaired. There could be multiple parties, even to what seems like a simple car crash. One of the ones that I worked on involved a passenger, not either of the drivers. So of course, we had the potential of trying to collect from multiple insurance informational statement that basically guides the lawyers and the judge on what's going on. And then there may be an order. The order may require the parties to cooperate on certain items of discovery. We did this one. We haven't done this one. We haven't done that one. Often in most states, the request for a production will be all one document. Production means give me your documents and things and photos or recordings of things. Questions, comments? There's a big mental block that some lawyers have, and I want you to break the mental block. Remember when I said, don't ask a yes, no question? For interrogatories? Don't even think about asking one? Don't even ask a preliminary yes or no question to set up the stage for a real question? And I know lawyers do it all the time, but they're wrong. I'm older than they are. I can tell them, I can say they're wrong. Yeah, they can get by with it if they have extra questions to ask in their state, but I have to teach paralegals the truth, which is don't use them and waste an interrogatory. And if the lawyer insists on asking them, I don't know, because of some misplaced politeness that does not apply to suing somebody, I guess that's up to the lawyer if they really want to do that, but don't do it in my class. But don't even ask a preliminary yes or no question. Before doing a correct one. And the same thing, the same principle applies to production, okay? Of documents and things. If you haven't already asked them to describe, let's say you did an interrogatory, and you asked them to describe all reports that have been ordered. Then you already know that there are reports on the accident scene. Okay. But let's say we don't know. Can you still demand the reports when you don't know there are? Of course you can. All reports made by law enforcement or by investigators, accident reconstructionists, experts, um, and by others about the crash. Who thinks that that's impolite and unfair to ask for something when we don't know it exists? I realize I'm putting you on the spot, but um, in regular what do you want to call it? Polite society friendship, you don't demand stuff from people. You don't say, um, "Here, give me your diary. Give me your tax return." You don't do that, do you? In friendship ethics, we don't demand stuff. And I think some of my students, due to personality, they wanna use their real personality, their home friendship personality. They want to use that in the law office. Don't do that. Um, in a lawsuit, we are aggressively going after the truth, and we're against the other side. We're not their pals. We're not their friends. Even if we used to be their friends, we're not their friends now. I mean, and I've been there, done that. I live in a small town. I had to sue two insurance agents that I got along with. Um, Two insurance agents, a guy who owned a business, um, various other insurance companies. Um, Not fun. They didn't want to look at me. They wouldn't say hi to me anymore. But you can't be buddies. Um, yes, demand it. Don't ask if they have any first. Any yes or no questions preliminary to asking for a document or thing. Questions, problems, comments? Go ahead. I mean, um, I'm more than happy to explain why I take this position. And I will tell you that the other side's lawyer is going to tell him that it sounds impolite, but it's part of the law. Hey, we're required to do that. Um, it sounds more hostile than people are used to being, but it's not. It's part of what we're required to do by ethics. We're required to assertively go after the information we need, and they're required to dig out whatever they've got and send it to us. And we don't have to ask them if they have one before we do that. Um, how about tax returns? If they're at all relevant to the case, um, tax returns, we don't have to ask them if they filled out taxes. Just demand them. All tax forms for years 2021, 2020, 2019. Same thing with if you want all insurance policies on that car for the year 2020. Any questions about that, about why we just demand it and we don't mess around? Because to me, that's a big deal. Um, if you draft it correctly and the lawyer says, well, they always ask a preliminary yes or no, you can politely ask the lawyer why bother? We're entitled to it. But if they insist on doing that kind of a thing, I guess you can comply with the lawyer. But I think you're better off doing a normal demand on the official document, and you can do a nice, sweet letter along with it saying, um, please follow the law. If we've demanded something that you don't have, remember that you can just say that you don't have any. But I want them to say it right in the official response document that they don't have any, rather than have us ask a question in something that's not an interrogatory. It's not a request for admission. Technically, you've asked them if they have something. Um, and then you're going to demand it later. And I think that the judges, let's say that they just don't comply, the judge may say, well, you asked a stupid question about whether they had it, and they don't have to answer that since this is a request for production of documents. You were unclear. You know, um, I'm looking ahead to the idea that the other side is going to be cagey and clever and not do what we ask them to do if the judge won't enforce it. They're only going to do what's enforceable. Um, there's two kinds of um, medical evidence, and one of them is just the medical records themselves. And people think, if I have the medical records, why would I ever need expert testimony? Well, sometimes medical records do not talk for themselves. For one thing, they're written in Greek and Latin. I'll put in English letters. I realize that, the Greek is put into English letters, true, but um, medical records are meaningless to the jury unless explained. And they may be fairly meaningless, sometimes meaningful, but not clear, even to a skilled arbitrator who has done personal injury law before becoming an arbitrator. Or been a judge before becoming a arbitrator, because there's always something new. You know, they say, well, this created this kind of a reticulation problem, um, and so on. And if the arbitrator has never heard of that before, um, a certain problem with the knee or whatever, the arbitrator may just say, well, that's interesting. I see it in the record, but it doesn't mean anything to me. I don't know how bad that is or how much injury that's going to cause. May not be clear from a medical record that a person is injured for life, because they don't necessarily put that into a medical record, a normal medical record that somebody is predicted to never recover. Who wants to do that as a doctor? That's not usually their job. So uh, at some point, though, they may be willing to testify as experts that there's permanency. Permanency is another word that's sort of an invented word, but it's used in the personal injury. Sometimes lawyers don't even want to sue until they know if there's permanent injuries that are personal injury to the human being. One of the problems with this assignment is students don't want to do a boring list of types of damages, but that's what's necessary. That's another reason why I like the table format. So types of damages, not just your guesstimate on how much. Questions or problems with that? So as you go through the Module 5 lesson notes, and as you go through the damages portion of the text, you might say, well, this is too hard. That's a lot of detail work. How do I know if I'm done it or not? And I would just say instead of trying to do a fancy essay memorandum, I would do the same thing that a bunch of you have already been doing, and do a table so you're clear what you covered, what you didn't cover. Did you show where you got it? Did you use the text? And people say, well, I thought we had to do original research on everything. No, you don't have to do original research on everything, but you can use the text over and over, and then you can do original thinking and original writing, so that the explanation of what you found in the text is all from you, not from anybody else, not from some webmaster or not from some lawyer's blog. So I would do it, if I were to do it, I would do it similar to the way a lot of you are already doing your work. You know, you have types of damages that Mary can seek. Um, and for everything, you have a source. Um, you know, and then you got an explanation, which is an application to the story. And you can add more if you want. Um, Comments, questions, fact gaps. I love that because I can really see the wheels turning. I know you're thinking through it if you do that. It's easy to give you points. It's hard not to give you points. If you have questions or if you talk about fact gaps, you say, well, I just don't know if that type of damage is applicable. True. How many times don't lawyers have to talk about that? Say, well, let's see whether we can really prove that. But at the beginning of the case, let's do a complete list of every type of damage that could possibly apply. And then paralegal, I'd like you to show me how much you really know about this. Where did you get this from? And a textbook is a good start. Um, and in the when you're taking the torts course for the first time, or the only torts course you're taking before you get out into the doing it in the working world at a high level, um, just get used to the idea that you talk about what you found in the text and cite the text and keep doing it and doing it and doing it. Then apply each type of damage to the story. And you say, well, there is no application to some of those. True, but then state that. Why doesn't that type of damage apply? To me, that's easy. And you say, well, that's a lot of organization. But what are paralegals at a higher level? Organizers. You've got all those thoughts going around in your head. The lawyer has a lot of thoughts, and lawyers, I realize, are often great memorizers and so on. But where lawyers really excel is on the logical side of things. And they love it if somebody organizes the logic where the application matches up with a source, a type of damage. Um, this relates to this, relates to this, and then right across from there is the problems or the questions. Then they say, wasn't there a problem? They have to set the case aside while the doctors are reevaluating their part of it. The insurance company is kind of chewing on it. Then you have a type of damage, and the lawyer wants to skip right to that. Oh, yeah, that's the one we were having problems with. We didn't think it was. Oh, and you mentioned that over here. So they can skip ahead to wherever they want to go. Like I say, it's may not be easy from a certain point of view, but it's actually easier to be organized than it is to go in circles. and it's more memorable than doing what some of the students do, is try to find a website for each question. That seems like that's not even education. That's just worthless. You find a website for everything, and the lawyer can do that in 5 minutes. Why would they hire you? They don't need to hire you to retail somebody else's thinking from a year or two ago on a different case. They want you to think about this case. Mary Bowman plaintiff, types of damages, not just your guesstimate. So outline possible damages. It's not just, again, types of damages, and then create the request for production. And T-bone crash is pretty terrible. T-bone meaning um, that way. She went through a green light. So let's say Mary is going this way. And then when she reaches the intersection, the other car running the red light hits her on the driver's side where she's driving, right? Terrible. Internal injuries, broken arm, broken leg, um, and will not have any sick time stored up. A permanent problem. Um, and of course, you might say, well, there's still fact gaps. Permanent limp. How bad is the limp? How much does it disturb her normal occupations of the things you have to do every day? Um, how much is it going to change things? It doesn't really mention um, how much physical pain, emotional pain from not being able to work. Um, you know, a lot of people skip the car, but don't skip the car. Uh, it doesn't really mention in here everything either. If she was in the hospital, doesn't that cost money? Aren't there some special damages, like some? I realize that there may be no fault money for some of the money, but I still, for some of the hospital bills and such, but I still want you to mention it as special damages. Um, it doesn't say if she has a child, uh, a spouse who could claim, and so on. There's a lot of fact gaps in there, but there have to be, because we're not going to give you a 10-page paper of facts. Um, Again, this is just covering what I already covered. Do you have to ask if they have any items before you demand production? Would you have to ask whether they have any income tax forms before you ask them? No, do not ask. No, just demand the forms. No, just demand the policies. Okay. Yeah, it's misplaced. It's either confusion or misplaced politeness that has nothing to do with the case to ask if they have something. Um, you could have asked interrogatories. Um, you could ask them for lists of insurance and so on. And then when you demand documents, you could ask them to provide copies of them, but you don't even have to do that. Do at least 5. Don't do canned ones. Don't do ones you found. Do your own. Do your own, not ones you find. Please. I hate just getting a bunch of canned ones. I think that has no educational value. Um, I hate failing a lot of people just because they give me canned stuff they found in 2 minutes. But I also don't like to give somebody points for something where they learn Zippo, they learn zero. That does not make sense. Um, any questions about that part of it? Request for production. And that is not the whole thing, of course. You do want to list the damages types. And here's the magic words as general damages. And maybe I should sort of display the module 5 portions that are so helpful and lead you into they'll make the textbook so much more understandable if you just have quick lists that you take from here and then look them up in the text. But you ready? So you say, well, why would I use this? You use this because um, you can get property damage and understand it very rapidly with just a few paragraphs, but then go into some detail. And when you look it up in the textbook, and then physical harm, you've got a very good list. This was obviously, the course was obviously created by somebody who knows personal injury and knows that they want to have really skilled paralegals who are thorough. So um, you would make a complete list, and those non-applicable items would just show on your table or memorandum if you don't want to use the table as not applicable. For instance, if you feel like um, these loss of support and substitute domestic services, those are not applicable, I would still have a list of non-applicable things, okay? Loss of companionship consortium, injury to reputation, you might say those are not applicable. I think it'd be better to list them all. Why lose the points? You might as well get the points. I'm going to also, I think that would pay to use the text more than people have been doing. I don't know where they get this idea. Where do people get the idea that they should ignore the textbook? I mean, that doesn't make any sense to me. That's it's so much better and so much more usable than um, what people are finding on the web. They're finding dumb stuff on the open web that teaches them nothing. And to the extent it teaches them something, it doesn't teach them enough. They don't get enough of an overview. They are getting just um, little snippets. And we'll just take a peek at chapter 4 and chapter summary key terms. I think that that's so important. So you go to chapter 4, damages, um, and it's going to give you an idea of general damages, special damages, economic loss, compensatory, and so on. Um, and then you can go to the key terms. And you go back to table of contents. And then, of course, you go over the medical records a little bit and you say, well, I'm going to ask for medical records. and know a little more about that. So chapter 12 would definitely help you too, I would say. Um, and this is just an overview of module 6, which I will have another session, or I will at least give you a recording, even though there's no independent points for module 6, but I'm planning to do that on Monday, a week from today, on module 6, and I hope you two can attend. But thanks for working with me on module 5. Questions or stuff I didn't answer?
I actually have one question. So for the IRAC, are we supposed to be making a table for each element or just like each type of the damage?
I would just say for the damages, um, I would be satisfied if you just have a list of damages, um, sort of like are in the lesson notes. Well, I would say I would just use the ones in the lesson notes, and then you could maybe lump the ones that you're pretty sure are not applicable at all. You could lump them into just one portion and just state these appear to be not applicable, cannot find any application to the story. How's that?
Okay, sounds good. Thank you.
You're just trying to apply each item, and then you can just say I got the list from the lesson notes, and then I supplemented it with the text.
Okay.
And then find pages in the text that helps you with the more difficult items of damages. That's what I would suggest. And that way I know you page through the text. And then of course, then you can focus when you've got enough sites in there, then you can focus on the part where you explain it yourself.
Okay.
The ifs, ands, and buts. You say, well, um, we really don't know. We know that the limp is permanent, but we don't know this, that, and the other thing about how bad the limp is. But it still looks like it applies to this type of damage.
Okay, yeah, that makes sense.
Yeah. Yeah. It's just personal thinking is like, is the most major thing because that's the only thing that makes education memorable for adults. And I think that actually goes all the way back into earlier schooling too. Um, Stuff that we actually mentally engaged in, we remember. I remember things from 60 years back that I mentally engaged in.
Yeah, that
You
definitely is
know,
true.
yeah, but stuff that just somebody force fed me and or something that I just was required to write out. No, I don't remember all that, but what I tackled, yeah. Okay, well, thanks. I'm going to stop recording and we are going to call it a night and meet again next week for the last time.
All right,
Thanks.
thank you.
Yep. Thanks, folks. Thanks, Brittany. Thanks, Paige.